At this time, it's my honor to introduce our luncheon speaker this afternoon. We're really excited to have Talley with us. He's the director of the Disability Integration Project at Atlanta Legal Aid Society and the creator of the website olmsteadrights.org. Atlanta Legal Aid, of course, brought suit against the state of Georgia that resulted in the historic Olmstead decision, which held that individuals with disabilities have the right to live and receive supports in the community rather than in institutions under the ADA. His staunch advocacy on behalf of people with disabilities, his attendance at Duke University Law School, his national reputation as a dynamic speaker notwithstanding, the only accomplishment that he insisted we mention in his introduction this afternoon is the fact that he's a former skipper on the world-famous Jungle Cruise at Walt Disney World. So please join me in welcoming our luncheon speaker and our skipper, Talley Wells. Thank you. Pleasure.
Is there a magic button? Oh, it's on? All right, yeah, we're still getting these microphone things in Atlanta. Hello, New York. This is awesome, y'all. This is an amazing conference. And it is a real honor to come to you from Atlanta, which is one of the epicenters of the seismic transformation that is happening because of the Olmstead decision. But we are not the only epicenter. New York is an epicenter. Oregon, Washington, Virginia, every single state, even Kansas, which is fighting it, is transforming because of the Olmstead decision, because of an artist who was caged, not because she had committed any sort of criminal offense, but because she had a different type of ability, because she had a developmental disability, she had a label of mental illness, she talks different. She was put in a cage. And I am so proud to work with Sue Jameson, who did the Olmstead case. And Sue is not the Thurgood Marshall of the Brown v. Board of Education decision, somebody who had just an incredible reputation and national stature at the time he brought this case. Sue was somebody who came to legal services because she wanted to represent people, individuals like Lois, like Elaine. She moved to Atlanta from Jacksonville when her husband got a job in Atlanta, and they bought their house across from the psychiatric hospital, which is now part of it's been torn down, and Emory campus is there. But they moved there, and she would take her dog and her 2 children across the street, and they would just go meet everybody in the psychiatric hospital, and she would become their voice. She came to Atlanta Legal Aid. She said, "I'd like to represent people with psychiatric disabilities." We said no. She said, "I'll do it for free." We said yes. She started representing people and was their voice. And then this remarkable new law came about. And it came about because of people like you in this room. People with disabilities demanded that the United States Congress pass a law to include every person with a disability, the Americans with Disabilities Act. It shocks me that that was just in 1991. So recently, we're going to celebrate, or 1990, we're going to celebrate the 25th anniversary next year, so it must be 1990 because 2015 is next year. But that law is really what Olmstead is. Olmstead is a very simple interpretation of the law. It was not a hard thing for the United States Supreme Court to say that Lois should have the right to live in the community like everyone else, because that was the law that President Bush signed, and it was the law of this land to basically encapsulate those fundamental rights of life, liberty, and the pursuit of happiness that every single American, despite or no matter their race, creed, ethnicity, or ability, has. And it's a no-duh. What's not a no-duh is how did it take till 1990? So we have this amazing law. Sue is just representing individuals one at a time, and she comes to know Lois Curtis. And Lois was this remarkable woman who befriended everyone she knew. And part of the best way to bring a big lawsuit is to have a great client. And Lois was that great client because everybody liked her. And all the people in the institution said, what the word we don't use, is she doing here in this institution? She should be able to live in the community. And so the doctors, the treatment professionals at Georgia Regional Hospital in Atlanta, which is a terrible place to live, but they said she should be able to live in the community. This is all she needs to live in the community. She's been here over and over again. There's no reason for that. She should get one of those Medicaid waivers. But you know what? We can't give her one. Because in Georgia, you have to be in an institution for people with developmental disabilities, and we put her in an institution for people with mental illness. Yeah, she qualifies, but she's in the wrong hospital. That's a whole building over. So we can't give her one of those, which is absurd. And so Atlanta Legal Aid brought this lawsuit, and it stood on the shoulders of giants in the disability advocacy community. Steve Gold and ADAPT had done this remarkable case called Helen L., which was brought on behalf of a woman in a nursing home, although if you see a picture of that nursing home, it looks a lot like a psychiatric hospital out of One Flew Over the Cuckoo's Nest. But she lived in this nursing home, and she wanted to be with her family, and she wanted to be in the community. Steve Gold and ADAPT brought this lawsuit, and the Third Circuit out of Pennsylvania said, yes, she has the right to live in the community. So Sue was doing this individual work. Our litigation director, who was a remarkable lawyer himself, said, Sue, let's bring this case. You've got the client, let's do this case like Steve Gold did up in Pennsylvania. They brought this case, and they won at the trial court. That was a great victory. But Tommy Olmstead said, and the state of Georgia said, no, we can't do this. It's going to cost too much money. We showed that it was actually going to be cheaper. But no, there were so many sort of entrenched interests to continue the system as it was. What would happen to the people working in the hospitals? What's going to happen if you let all these people with mental illness and developmental disabilities out of the institution? It's going to cost too much. They're going to be a danger to society. We can't do this. So they appealed to the United States Circuit Court in the 11th Circuit, which covers Florida, Georgia, and Alabama. We're not quite as liberal as New York, and so we had an expectation of conservative judges. We actually got a great panel of judges, but there was one judge, pretty conservative. I interviewed with him once, and he was about the scariest person I ever met. And there was no way we were going to get his vote, but we'd get the other two. 11th Circuit ruled 3-0 in favor of Lois Curtis and Elaine Wilson, saying that the state of Georgia had the obligation under the Americans with Disabilities Act to serve them in the community. Tommy Olmstead said, let's appeal that. They went up to the United States Supreme Court. That was a shock and very concerning that the U.S. Supreme Court would take the case, because there had only been one other decision out of the Third Circuit, and they ruled the same way that the 11th Circuit did. And pretty much the U.S. Supreme Court doesn't take cases unless there's a split between the various circuits. They're basically the decider if different courts around the country make different decisions. But we had two decisions the same way. So it must have meant the U.S. Supreme Court was going to rule against Lois and Elaine. And so the state of Georgia recruited all of these states, and they got all of these briefs from all these states saying it is going to be too expensive. You have got to reverse this decision, U.S. Supreme Court, and adapt. And the disability community rose up, and they went state by state to the leadership of these states and said, "What are you doing? You cannot take this position. This is America." And state by state that had told the U.S. Supreme Court that they shouldn't rule in Lois and Elaine's favor changed their mind, and they withdrew their briefs in support. And a number of them actually turned to the other side and wrote briefs opposing the brief that they had just wrote, saying that you need to support Lois and Elaine to live in the community because it's the right thing to do. And in a 6-3, part of it was 5-4 decision, the United States Supreme Court ruled in favor of Lois Curtis and her right to live in the community. They ruled in favor of Elaine Wilson and her right to live in the community. And they ruled in favor of every other American with a disability in an institution in their right to live in the community. Because what the Americans with Disabilities Act said, and it says this right at the beginning, is that this country historically had discriminated. They use that word. This country had segregated. They use that word. People with disabilities by forcing them to live in institutions. In Georgia, we have thousands of unmarked graves outside of Central State Hospital in Milledgeville, where thousands of people were sent because they had epilepsy, because they had a mental illness, because they had a developmental disability. They were sent to live their entire lives in this institution in the middle of Georgia, never to come out and to be buried in an unmarked grave. The United States Congress and President Bush, when they signed this act into law, said this is wrong. It has to stop. We have to change the system. And that every state in this land has an obligation to provide whatever supports and services it's providing in the most integrated setting, that every person who gets a support or service has the right to get that in the community. And not just in the community, but in an integrated setting so they can be just as much a part of American life as everybody else. And that is what the United States Supreme Court looked at when they examined the law, and that's simply what they said. It is not a complicated decision, although they write in such big words that it seems complicated. It's simple. It's just that everybody with a disability should not have to live in an institution. They should have the right to live in the community. That's what it said. So the experience in Georgia is that we got a great decision. But there was this sort of catch in the case where the U.S. Supreme Court said, well, you know what, this is actually going to be a pretty big deal. If you're going to make everybody who's in an institution return to the community, that's going to take a lot of work. You're going to have to do some planning. You're going to have to sort of transition this whole systems. So we're going to say it's okay if you have an effective working plan with reasonably paced moving waiting lists. We love that word, waiting list. And so as long as it's effective, it's working, it's a plan that moves, you can do that as a system. So what Georgia decided, and there were 49 other states who thought this was a good idea too, they would plan. And so you heard the individual who talked about New York's Olmstead plan coming 14 years later. Well, we're still waiting for ours in Georgia. We've actually got a fantastic Olmstead plan, and it is sitting on a shelf in the governor's office. and that's where it's probably going to sit for a lot longer. But what Georgia did was it created a blue ribbon committee, a super great committee, a governor's committee, a wow, we're really great committee, and they just created all these plans, but they never actually did anything. And it took we went from 1999 to 2007 when the Atlanta Journal-Constitution wrote these scathing articles about people dying, more than 100 people dying in our state institutions 8 years after Olmstead, who would have lived had they not been in these institutions. They wrote about Sarah Kreider, who was 14. She was 14 years old, had a developmental disability, beautiful girl, who was given medication she probably didn't need, vomited and choked on her vomit, and died. This story brought the United States Justice Department to Georgia. It galvanized the advocacy community. The Justice Department did this amazing investigation, found all of these problems with the institutions, and was going to change the system. And then the Friday before President George W. Bush left office and President Obama was inaugurated, the United States Justice Department entered into a weak cold fish settlement with the state of Georgia. It was junk, and we were mad, and we lawyers were outraged, but we thought there was nothing we could do. But thank God, a mental health advocate by the name of Cynthia Wainscott got all the mental health advocates in the state together, and they wrote a letter to the judge. And they said, Judge, you cannot authorize this settlement agreement. We lawyers thought, hey, there's nothing you can do. You got a contract. You got one party, you got the other party, they signed it. You can't do anything. Cynthia Wainscott wrote the judge. The judge refused to enter that settlement agreement. He forced the state of Georgia, the Justice Department, and the mental health advocacy community to sit together. Allison Barkoff, who you heard from today, was an integral part, as has the Bazelon Center throughout Olmstead, was an integral part in those discussions. Georgia and the Justice Department and the advocacy community fought, they bickered, but they also collaborated and came up with a really powerful settlement agreement that we are now in the 5th year of a 5-year settlement agreement. It calls for ending our institutions for people with developmental disabilities, getting everyone back in the community. It's not going perfectly, as we've discussed. There's still a lot of room for making it work, but we are working towards that goal that every person with a developmental disability has the right to live and work in the community. It has, and it's really actually a much stronger mental health settlement, and what is at the core of the mental health settlement is housing. So many people were locked up in our institutions because they didn't have a good, solid place where they could live. We looked at New York City and pathways to housing, and what y'all are doing in this city, enabling people to have good quality integrated housing, because housing has to come first, and then providing the mental health supports and really being person-centered about what a person needs for wellness and recovery. And we've rolled out these supports and services. There was a lot of grief and gnashing of teeth, particularly when each institution would close. But it's working. People's lives are being transformed. People who people said would never be able to live in the community are thriving and doing well in the community. Let me talk also about our housing vouchers. When we came up here in New York City and met with Samson Burris, and I came up here with the commissioner of our mental health system and the governor's mental health advisor. And we met with Samson Burris, who runs Pathways to Housing and Housing First. And they told us about the fact that the state of New York actually helps to pay a little housing, towards a little housing. I'm sure it's way not enough, but we never heard of anything like that in Georgia. And so we created these housing vouchers that ended up in the settlement agreement that enable a person with a severe and persistent mental illness, even if they have a criminal background, to get housing and then to keep it even if an issue arises. And that has been such a core for moving the settlement forward, and it's something I hope can become a model for the entire country, because it is working and it is cheaper, because people are living in the community, they're thriving, they're recovering, and their wellness journeys are going incredibly well. So one more big lesson, and then I'll wrap up, is that we have moved forward, but we have so much further to go. And when the Justice Department comes in, it's great. You get a wonderful settlement. People are helped who are in that settlement. But if you're not in that target population, you are basically, you can be ignored. Because once you have a settlement, then that becomes the whole focus. Georgia wants to get the settlement right. And so if you have been in crisis and you qualify for the mental health settlement, you get great supports and services and housing. But if you haven't yet hit crisis, you get squadoosh. You have to go into crisis first to get these supports and services in Georgia, because we have this settlement. So it's really critical to understand that we want a full spectrum system, and that you need to have the litigation, but you also have to have all of the policymakers, all of the advocates, everyone involved in building up an entire system for it to truly work. And then the other part is that we are in 2015. The settlement is ending. And when it's over, what happens next? We still have 7,000 people on our developmental disability waiting list. We still have people with traumatic brain injuries not getting anything. We still have people in nursing homes by the thousands. Yes, the earthquake is happening. Institutions are coming down. The transformation is happening in Georgia, and it's happening throughout the country. But we have just hit the 1 mile marker of a 100,000-mile journey. We have got to really work together and have the advocacy community work together to really build a system that truly encapsulates America's ideals of life, liberty, and the pursuit of happiness. And it is critical that it be individual first. So thank you very much, and I'll take a few questions if there's time. I don't know if there's time.
The one piece of the picture that we have not heard about today, we've heard about housing, we've heard about jobs. We have not heard about transportation, about mass transit, public transportation. This wouldn't apply to Curtis because her profession can be practiced at home. She's an artist. What if you are released from an institution and go on to become an accountant, a clerk, a lawyer, a counselor? But you don't have the wherewithal to buy a car or learn how to drive one. I mean, that we all know about that here in New York City. Atlanta, great city, lots of interesting neighborhoods. If you don't have a car, it takes about a year to get from one of those nice neighborhoods to another. What do you have to say about that?
I want to know about the shortcut that you're getting one place in just a year. The transportation is an absolutely integral and critical part of this, and I'm so glad you asked the question. It needs to be a part of every advocacy. The disability community, that's probably been their number one issue in Atlanta, has been accessible, quality public transit, and we have spent countless times. We've sued MARTA, which is our Atlanta transportation, sort of our subway, to the extent we have one. And it is critical, and it's even more critical in the rest of Georgia, because Atlanta actually has some public transit. But once you get out of Atlanta, you are stuck with basically sort of, if you have Medicaid, Medicaid will get you to your doctor's office within a month of when your appointment is. It is really a critical piece of all this. And the other part of this, of course, is that it's not just the people with disabilities right now. All of us have family members where that's going to become an issue. And so one of the things that we have to always be thinking about is how do we align ourselves with the larger community, because transportation is a critical component to people who are in the environmental movement, people who are getting older and may have some difficulty driving, people who want to save money. And so it is absolutely essential for transportation. Go ahead.
Understanding from stories in the Atlanta Constitution and other of your local publications that there have been reported excess deaths in the haste to move people out of the institutions, and I believe I've seen references to the process of moving them out being slowed because adequate consideration wasn't given to where they're going. And I was wondering what your sense was of that problem. Is it under better control now? And what do you do about folks who do need an institutional setting?
It is the biggest issue with our settlement agreement right now. I mentioned that there have been some significant issues with the DD transitions. It is, I don't think it's an Olmstead issue as much as a fact that we've got a mess in terms of the way our system leadership has been, and specifically our case management system and some of our providers. And we put in the state put in a moratorium, which the advocacy community totally supported, because it's not nearly as important to do this fast as it is to do it right. Every single person has to be ensured that they're going to be in a quality place, and that they're going to be safe, and that they're going to be able to have a rich ability to live and be in the community. The article you were referring to was from June in the AJC. Anybody who wants to look at it, it is a disturbing article, and it's important that we get it right, and that's been the insistence of the advocacy community, but also the state and the Justice Department. Everyone is on the same page in that the errors that, the tragedies that have happened have got to be corrected.
Would you agree that some of the folks on your waiver list would be better off in institutions, but institutions that truly provide the quality care that ICFs are supposed to provide?
I would agree that everyone would be better off if we truly invested in supports and services for people in the community to live where they choose to live, and that the real issue is underinvestment, poor leadership, and we've got to get that right. And whether or not, wherever you are on the discussion about whether everybody should live in the community or certain people should live in the institutions, we can all agree that we have to, as a country, invest in strong quality supports and services. Okay.
Real brief. It seems like with all the entire body of work of the panelists, their personal experiences as well as their professional career experiences, and them bearing witness to everything that we actually heard this afternoon and morning. From an advocate standpoint, can you speak to more of, what are the best practices that you can share with us now and for the rest of the afternoon that you have found have been key tools, strategies, presentations, whether it be public speaking, that will help us, help you, help us, help we in this endeavor? Because the underlying driver that I keep hearing from all the panelists, the undertone and the undercurrent, is advocacy, to really topple and create a tipping point whereby we can just hit the goal.
What a great question. Number one, it is so critical that people are at the center of this, that their stories are told, that people understand that Olmstead is happening, and that people are living better lives, and that this is a worthy investment. It is cheaper in the long run, but it takes an investment in the short term, and we have to get the stories out to show that this is the right thing to do. Number two, agencies are at the heart of implementing this a lot of times. And so in our state, it has been critical to ensure that we have quality leadership of the people who are going to actually implement Olmstead, that they get it, that they want to do it, and that they have the governor's ear and the budgeting to go along with it. And while it is fabulous every year to have a disability day where people go and talk to their legislators, and that's critical, it is also very important to know the people who are actually implementing the decisions and getting to know them, being at their meetings, but talking to them one-on-one. Then getting to know your legislator. You had the senator here today. It is absolutely critical, and one of our goals in Georgia is that as many people with disabilities know their legislators, and their legislators know what is happening with them, because as I said, we've completed the first mile of a 100-mile journey, and there's a lot more to do, and we've got to keep the momentum going. Because Allison mentioned Brown v. Board, and Brown v. Board is an ideal that America embraces, but if you look at our school systems, we still have a pretty much a separate but equal, or a separate but not equal system, despite the Brown decision. And we can't let that sort of momentum stop with Olmstead like it did in a lot of ways with Brown.